Well, good afternoon, everyone. Thank you for joining us today. Welcome to today's program. It's called Litigation Finance, Lessons from the Last Financial Crisis for the COVID-19 Downturn. And we are delighted to see you and see that you've joined us today. Please submit your questions throughout the presentation by using the question box on your screen. Also, the presenters will probably answer the questions mostly at the end of the program when we're able to address them during the question and answer period. And if you have any technical issues, you can contact us using the chat box as well, or simply hit the help button on the bottom of your screen. Well, I'm Cathy Reece with Fennemore Craig. Why don't we go to the introduction slide? So turn to slide 2. What we've done is provided our backgrounds on this slide, but what we really want you to pay attention to is our email addresses so that you can contact us afterwards and ask us any additional questions, or if there are issues that we can help you work your way through, or if you need some assistance besides calling Emily at Burford Capital for her financing. If there's anything else we can do to help direct you in the right direction, we are glad to do that. For my background, I'm the moderator for today, but I'm also a panelist, and I have represented both committees and trustees in large Ponzi scheme and security fraud type cases. Affinity fraud cases is what primarily I have been involved with, whether it's the Baptist, the Jewish community, the Greek community, certain sports teams, the Mormons. There are a variety of affinity fraud cases that surface in my part of the country. I'm based in Phoenix, and that's where I primarily in Arizona and Nevada have litigated. The types of Ponzi scheme or even affinity fraud type cases I've had, and the other cases where I've been able to draft the plans, be a plan proponent, I've been able to really develop the trust documents that are necessary, the plan, the confirmation order, the trust agreement, and then also be able to continue to work with the entities afterwards and implement the plan itself. And so that's where my expertise and what I'm going to contribute to this program stays in line with. We have both Emily Slater and Eric Fisher with us. Emily, why don't you introduce yourself?
Sure. Hi, good afternoon, everyone. Thank you for joining. I'm Emily Slater. I'm a managing director at Burford Capital. I've been with Burford for 10 years. And over the course of Burford's history, I have developed our underwriting process and underwritten billions of dollars worth of litigation funding investments, everything from a very basic classic litigation single case financing of a litigant to multi-hundred-million-dollar portfolios with companies and law firms. Prior to Burford, I was a litigator at Debevoise and Plimpton for almost 10 years, and I dabbled in the bankruptcy space and have been focused on developing litigation finance in the bankruptcy space over the course of my time at Burford. Eric?
Great. Good afternoon, everyone. Cathy and Emily, it's great to be presenting with you this afternoon. I'm a partner at Binder and Schwartz. We are a commercial litigation boutique that is based in New York City. My background really is as a trial lawyer. I spent time in the civil division in the U.S. Attorney's Office in the Southern District of New York. But over the past decade plus, my practice is really focused on bankruptcy-related litigation, and in particular, high-stakes bankruptcy litigation where the plaintiff, often a litigation trust or committee of creditors, ad hoc or official, is adverse to large financial institutions.
Why don't we move on to slide 3? Today, as we're going through the third-party litigation, we're only talking about commercial cases, not consumer cases, and there's a big difference. But in the commercial arena, what we're going to talk about today is kind of an overview of litigation financing, and then we're going to talk about specific issues related to liquidating trusts. And finally, we have 3 case studies we want to go through briefly with you so that you can see how it actually works and how it can be helpful to your client. Emily, so what is third-party litigation finance and what's a good case for litigation finance?
Sure, happy to talk about that. So third-party litigation finance is really just specialty finance that is based on the value of a litigation, primarily affirmative litigation. As Cathy said, we really focus on commercial litigation between companies or business people involved in companies, everything from standard contract disputes, ownership disputes. In the bankruptcy case, a lot of D&O litigation, fraudulent conveyance, and other kinds of avoidance actions, and disputes between creditor groups, all kinds of disputes in that area. Litigation finance is really just, it's not really any different than a company would finance do any other asset-based finance, like financing a building, even financing a copy machine. Really, it is looking at what the risk discounted value of a litigation is and advancing cash to a company or law firm in order to proceed with the litigation. Generally, classic litigation finance is really parties seeking finance in order to actually pay for litigation fees and expenses for the funded party, whether that be a company or a law firm who may have a contingency arrangement that they can themselves finance. More recently, monetization has been a big priority for a lot of companies that have large litigations, and companies in bankruptcy have done, where they have large claims in antitrust cases and other matters where they may be able to assign or sell the claim and receive a cash recovery for that today in return for a payment later back to the litigation funding provider. So a litigation funding agreement, fundamentally is non-recourse investment. It's not a loan. It's a no-win, no-pay, similar to a contingency. And the litigation funding agreement makes a sort of contingency-like relationship with the funded party. As I said, proceeds generally fund the cost of litigation, but more and more frequently we're seeing monetizations of claims, which is just essentially getting, paid some value today for the claim. The capital can be used for any business purpose, and when the case resolves, a return is paid to the funder. It's used by businesses and individuals, but it would be in a very significant corporate dispute. Generally, we see individuals looking for funding when there may be some kind of significant partnership or ownership dispute of a company. The litigation funding is really available at any point in a litigation life cycle. So we very often see companies coming to us early on, before they file a case, and have an assessment from us and are interested in funding from the get-go. Frequently, we also have, Cathy, would you mind muting?
Glad to. Sorry.
Frequently, we also will see a company come to us. I think, they may have engaged in early settlement discussions and maybe even file a claim to see if they can resolve a dispute without a full-fledged litigation, and that may or may not happen. And so very frequently, once a case gets into litigation or gets into discovery, we'll see parties really interested in financing their claims at that stage. But anywhere through the litigation cycle, all the way up to and through trial. And then there's a very, very active market of financing judgments after trial. It's very attractive. There's a lot of certainty, and appellate risk is a lot lower than pretrial risk. So there's the very active market for that kind of monetization as well. As I mentioned, an arrangement can be with either a party, a litigant, or with a law firm. So, very frequently we are funding a litigant for their to pay for their litigation fees and expenses, or monetize a claim. And also, we work frequently with law firms that may have a case that it is taken on contingency, or a group of cases that is taken on contingency, and the firm wants to finance their expected, finance cash today to help them manage their cash flow based on the value of their expected return on their contingencies. So that's an active area of business as well. Funding is passive. The funder generally has no control over the litigation strategy or settlement. That is, very much the case when we do funding agreements with litigants, and especially the case where we do funding agreements with law firms. Typically, we really have no interaction with the claimants, and the law firm obviously is obligated to act, only in the interest of the litigant, and the litigant drives and controls the lawyer-client relationship. So that's a very important part, particularly in the bankruptcy space, as we'll talk about a little bit later, when we're financing a trustee or a trust, ensuring that the trustee is independent and able to make their own decisions around litigation strategy and especially settlement. Funder communications are, and the funding agreement, there's a well-developed law now around attorney work product protection, protecting communications between clients, funders, and lawyers. And that is pretty broad, and we've developed that in state courts and federal courts around the U.S. And it's very, very often the very first question that we get from lawyers and clients is making sure that there's confidentiality protection for communications, and that a funding agreement and a funding process is not going to create any waiver issues in a case. The next question is always, how much is it going to cost? And our investment pricing is really sort of individual. Litigations, for the most part, are not widgets. They all have their individual risks, timelines, their own underlying facts. And so the form and substance of deals can vary quite significantly across deals. But I think it's fair to say that litigation finance, because it is non-recourse pricing, if the funder is taking the principal risk from the outset of the case on the cost, it's not too different in terms of cost from what a traditional contingency fee might be. There's a lot more flexibility and ways to structure it. And, all the way going from, financing post-judgment appeals, there we're looking at a funder would probably be looking for kind of a doubling their money, 1x return on that kind of monetization. So there's a very wide range in pricing. There's also very wide range in pricing in portfolio financing, where there might be a lot more shared risk. And, with very large portfolios, there may even be a deal where we do a monetization for a non-recourse interest rate. That would be, far, far less expensive than your typical single case financing from the outset of the case. Can we go to slide 4, please? So what is a good case for litigation finance? For the lawyers on the call, that have done contingency work, it's not really so different from doing a risk assessment when you might think about taking on a new contingency case. First and foremost, because it is a non-recourse investment, we really look closely and think hard about the merits of the case. And we really like to have a very strong case on the merits. And, really, even like a 50-50 case would be very difficult for Burford to get behind. And I think, sometimes people might think about, well, maybe I'll do this very high risk case because it's a very high reward case. I'd say most serious funders don't take that approach to funding litigation. We really focus on meritorious litigation because we lose all our capital. I mean, it really just, you can get into the poorhouse very quickly by funding a lot of very high risk cases. So we very much focus on strong merits, and an experienced law firm with a successful track record is also key, especially because we do very often see cases with smaller companies going up against much larger, repeat players in the litigation space that are highly sophisticated and have very highly sophisticated counsel and a lot of money to drive up expense. So we really need lawyers that have a significant track record of taking on huge cases and being able to efficiently manage them and bring them to a strategic conclusion. Cases that have, along with the merits, supported by substantial evidence and legal precedent. At Burford, we don't really like taking risk on kind of cases of first impression. We like to know that there's obviously risk in cases, and sometimes you may be extending precedent out there a little bit, or taking, this is a business about the gray, but we don't really like to be kind of the first out there to be taking on a whole new area of law or extending, sort of making a new pathway and something that would be very high risk. We also, because we are extending capital, at the end of the case, if it's successful, we like getting paid back. We like cases that have a monetary result, or result of the transfer of value that can be easily valued and liquidated or monetized so that we can get paid out. We'll talk about it a little bit later. We have ended up sometimes with a patent or a piece of real estate, but we much prefer getting cash. And so we primarily look at cases where there is a cash outcome. Sort of a return to status quo ante or injunctive relief is something that simply, it's interesting in a legal way, but it's not very interesting to us as a capital provider. Damages have to be well supported and significantly exceed the amount of requested financing. So I'd say the rule of thumb in the industry is that you have about 10 million of real settlement value for every 1 million of invested capital, to make sure that there is I think everyone likes using that ratio, because hardly ever does a case come in bigger than you think it will. It's, those are good days when that happens, but usually something comes in at the middle or lower end of the range where you think it may. And we really want to structure incentives to make sure that the lawyers are incentivized and the client in particular still has the majority of the upside in the case if the case performs as expected. We want the client to be incentivized to fight the case hard, and also to be able to take a reasonable settlement when this reasonable settlement is on the table, and that that there hasn't been so much funded that the funder is really ending up with the bulk of the return. So we'd like to have that nice ratio in terms of funding amount versus value. And then in terms of damages, we really, for Burford, we like to think that the case is big enough. We don't need to necessarily have an exact number. We don't need generally an expert report or significant work done on damages by experts, but we do have to have a very good sense. And sometimes there'll be a contemporaneous valuation or other kinds of benchmarks that we can use to satisfy ourselves that the case is really big enough to support the investment that it needs. And finally, we do a fair amount of work around the creditworthiness of the defendant. Right now in COVID era, companies that had been, sterling credit risks are really struggling. And so those are things that we look at and make sure that there's not a lot of bankruptcy risk on the defendant side as a result of the judgment, and that they're going to be able to pay whatever the cash is that is going to come due when there's a settlement or an award. Next slide, please. Oh, you're on mute, Cathy.
Now we want to talk about how we begin the process, if you're the counsel for the trust or for the plaintiff that's involved. And so one of the first things is to make sure that you do the due diligence on the funder, to make sure that the funder has the money and will have the money available to pay you when you need it to be paid. whether it's a lump sum up front, whether it is monthly amounts, how you structure it. You just need to make sure they have the money, and finding out what their source of money is, I think, is one of those due diligence issues besides getting references for the fund that you'll want to look at. The next thing is making sure you always have a non-disclosure agreement right up front when you're talking with the funder to make sure that all of your conversations are protected and any information that you give them is protected. Emily's already talked about the fact that attorney-client privilege we hardly ever share with the funder, because the case law isn't as strong on that as the work product privilege. Work product privilege is much easier to protect, but regardless of what you're going to give to the funder, you need to make sure that you have a non-disclosure agreement. Most of them are pretty standard forms from funder to funder. Sometimes your firm will have its own agreement that it wants to use. The next thing is actually gathering the information in order to provide. I think Emily was spelled some of it out, but I mean, it's primarily the complaint, the various public pleadings that you have, certain things that are likely to show them about the issues that are there. And so they'll come up with the list, you'll come up with the list, and you will then be able to get enough information they can look at it. The next thing is looking at the value of the claim. I mean, as attorneys, we oftentimes feel what we think is the value. This is an unusual area. I mean, sure, we're used to asset-based lending where you have equipment and inventory and accounts that you can try and value. Litigation is oftentimes hard to value. But as a law firm, if you've already taken it on contingent fee, you probably have a good idea about what you think the value is in settlement, as well as the value of what you're going to be asking that jury for. And so that's how you start working through the value of the claim, because I want to know what you think is the value. The next thing is the budget, always making sure, and even as a firm who's taken it on a contingent fee, you also have a budget for your fees and your costs and your timeframes, and you spread it out on your spreadsheet in order to determine that. And again, the funder is going to want to know those types of things. And if you're being paid monthly, you're going to want to have your actual amount coming in from the funder, or quarterly. You're going to want to make sure that you are actual to budget, that you're right on, that you're not exceeding your budget. Next is you're going to get a draft of a term sheet from the funder if they're interested in going forward. And so funding that term sheet is going to be important. And going through the terms, figuring it out, making sure that if as a law firm, if you are the party that is being funded, or if the plaintiff is being funded, make sure you understand what's going to happen on the payout. When the recovery comes in, what is going to happen? And if the recovery is not cash, how are the parties going to react and respond? And as you will be able to tell from the last case study we're going to do today, that is also an important issue to make sure you cover. Next is choosing who will be the funded party, because it could be, as Emily explained, either the law firm or it could be the plaintiff that is going to be the funded party. And choosing the structure, whether you're going to do it if you're in a bankruptcy or if you're outside the bankruptcy in a post-confirmation setting, are you still going to go in and get approval? Is it going to be a sale of a portion of the right of recovery? Is it going to be 364 type funding, which is viewed in a certain way under the bankruptcy code, or not? And so choosing the structure, I think, is also important. Next is reviewing the draft documents as you go through them. And if you are the law firm and it is the funding of your portfolio or your law firm, you may want to consider getting special counsel for the plaintiff so that you can make sure that your client understands what's going on there, and that the plaintiff continues to be in control of the lawsuit. If you're looking through the draft documents, make sure you have that provision in there. Most of the funders have it, but you want to make sure that it's crystal clear that it's the plaintiff who controls the lawsuit, the strategy, the settlement, all the major key issues in the case. And the funder might be entitled to information and reports, but it can make certain statements or ask questions or make its suggestions, but it's the client, it's the funder who doesn't control, and the plaintiff who does control. And then lastly, think through the structure as to whether or not you think you want court approval for this or not. If it's in a bankruptcy, you'll need it. If it is pursuant to a plan, you might be able to get the permission in the confirmation order. If it's post-confirmation, think about the trust document or whatever your post-confirmation entity is and whether or not you want to seek court approval for doing that. Next slide, please. In this specific one, what I wanted to talk about is using your liquidating trust as a mechanism, because it is a very common thing now. It's more prevalent since 2008. I've had some that were before that, but there are a lot more liquidating trusts or litigation trusts. It's either, you can call it either thing. You know, they're used a lot in the 524 asbestos cases, the sexual abuse type cases of the dioceses or the Boy Scouts. It's also used as a protection for future claimants, if there are future claimants that are involved. And so liquidating trusts are very, very common now and an excellent mechanism. Sometimes it's part of the prepackaged plan, if that's negotiated in advance, that the litigation and certain things will go into a litigation or a liquidating trust. Also, if the debtor during the bankruptcy is going to be selling its assets, it may very well decide it'll sell the assets and as a part of its plan, put the causes of action and certain types of claims and certain assets into the trust in order for it to be distributed over a period of time to the creditors. Another one is where the debtor actually wants to reorganize, but it wants to be free of the litigation and the issues that can be put into a litigating trust. So the debtor can go ahead and sell its assets, but keep the business, put the causes of action into a litigation or liquidation trust for the benefit of the creditors. There are a lot of different things that can be put into the trust, so it'll be something you'll want to think through. Providing the funding is just an additional thing that you can have the trust have available as an access for its high value claims. I mean, the way we used to do this is that the law firms provided the funding because they were doing a contingent fee. Now what's really nice for law firms is to be able to have a source of additional funds so it doesn't have to carry the risk all by itself. And that for a law firm is really helpful. I'm on our firm's contingent fee committee. And so looking at a contingent fee case when we get it in and whether or not it could really qualify for funding is important and can help us to be able to figure out how we manage our revenues over a period of time while still taking a contingent fee case that otherwise might not be able to be pursued. So if the litigation fails to provide a recovery, the good thing is that it doesn't hurt the beneficiaries of the trust because the financial burden is with the funder. It is a non-recourse loan funding. And so that is what's really unique. Just like the law firm isn't owed any funds, the funder isn't owed any funds. The pricing is negotiated. I like the idea of the portfolios so that, you know, the law firm can take advantage, or the trustee in a Chapter 7 can take advantage of, or in a liquidating trust of a portfolio, 2 or 3 recoveries, 4 or 5 recoveries that can then you pledge those, and then you're able to reduce the price of the actual the funding itself. The benefits, I mean, one of the benefits that I really like is that it levels the playing field. Because if you're litigating, you're oftentimes litigating against deep pocket defendants. And so this helps to level the playing field by having funding available, not only the law firm on contingent fee, but actually getting the funding that's there. It also allows you to preserve recoveries for the creditors. And otherwise, you might have to abandon the lawsuit if you can't get some type of assistance in this area. It also can accelerate and be more efficient recoveries for the creditors because it speeds up the recovery and the ability to use some monies for partial distributions under the post-confirmation time period. And it is capital that can be used to fund the administrative expenses if you need that, and which I think is really helpful in certain situations. Let's move on to the next slide, please. In this slide, what I wanted to do is just point out a couple of issues that I think are, if you're going to be doing trust, you need to be aware of. The first one is when you're going through the plan process, the confirmation order, then you do the trust agreement, and then you move forward from there. As you are back in the plan and you're in the Chapter 11, think through what are the causes of action that you really want to have put into a trust, because there's a split of circuits on what it is and how you describe it and what you do. So, for example, in the First Circuit in the In Re Bankvest capital case, the court there, the First Circuit actually said that a general reservation of the potential defendants and the causes of action is enough. You don't need to be specific. You can indicate the type, the category, avoidance funds, other types of things. So in the First Circuit, that is really helpful. But if you're in the Fifth Circuit, beware, because the specific type of cause of action needs to be listed there. In the Fifth Circuit, in the Roscoe Holdings versus McConnell case, in that particular Fifth Circuit case, the court said that it required specific and unequivocal information preserving the litigation. It was not enough to do just a general disclaimer or disclosure. And so that's going to be important to the funder, because the funder is going to want to know that later on in the litigation, there's not going to be a dismissal because of a lack of standing in order to bring this. And that oftentimes is one of the either first motions or a motion before you get to trial is a dismissal for that. So beware, you need to know that. Another type of split of circuits that you kind of need to be aware of is the type of plaintiffs. Most of the time you think of the plaintiff in this is going to be the trust, the litigation trust. You're going to get the debtor's derivative causes of action, and you're standing in the shoes of the debtor under 1123. And that's true. Most of the time that's it. But sometimes you also realize that the individual creditor claims, the people who relied upon the financial statements or people who relied upon the specific opinion that was given, they, have their own independent cause of action. Can they assign it to the trust so that the trust brings not only the derivative suit, but also the direct suit? Sometimes that's a real benefit. And again, that could be, you could do that under the plan, but you got to be careful of which circuit you're in. In the Ninth Circuit, for example, in the Williams versus California First Bank case, there the bankruptcy trustee, even though it had a court order, and even though it had a specific assignment from the direct creditors, did not have standing to bring the direct claims. So those direct claims got dismissed out of the lawsuit, and if the statute of limitations was already gone, then that was a real problem for the creditors. And so in that circumstance, you might not want the direct claims to be a part of the trust, and instead the trust works with a class action counsel or works with some other counsel who together they can bring the claims, but they're not assigned. Whereas in the Seventh Circuit and in the Second Circuit, those courts have indicated in the Seventh Circuit in Grady versus BNY Mellon, and in the Second Circuit in CBI Holding Company. In those cases, the independent entity, separate from the liquidating trust, could have the claims prosecuted by the trustee. And so the trustee could represent the creditors, and they've had their due process. They've had their ability to stay on the outside of it. But in a plan, if you've approved all of that and it's the direct claims and they've been assigned, then the Second and the Seventh Circuit have both said that's okay. So again, beware, because those could be dismissed. Then the last thing I kind of wanted to make sure that we cover in this specific area is, besides those 2 points on the splits of the circuit, that one of the important things is making sure that you transfer the privilege of the debtor or of the committee, because they've had confidential discussions, confidential information, and they've had the ability to gather certain types of things that you might want as being the trustee or the trustee's counsel in that situation. Reservation of jurisdiction in the confirmation order in the plan is something you really want to think through precisely. You want to decide whether or not you want that. A lot of liquidating trusts and litigation trusts do not have the jurisdiction continue, and some courts are hesitant to allow that. But the idea is that either it's expressed and you let the jurisdiction continue, or you build in enough of hedging language so that the close nexus that can be the type of information that, it implements the plan, it implements the payment of the creditors, so therefore the court has related to or has jurisdiction because of that. And there's a doctrine by the Supreme Court called the Barton Doctrine, which said if you're going to set up this kind of a trust and you're going to be in a plan, then you can determine the court who set it up in the first place. The bankruptcy court is the one who determines where the suit is to be pursued, whether it's going to be in the bankruptcy court or it's going to be in a federal court or a state court. And then of course, the next thing is in In re Harris, which is a Ninth Circuit case. the idea of why you want the court to have jurisdiction and approve the process, approve a settlement, approve a sale, be involved in it where you provide notice to the creditors post confirmation, is so that you, as the trustee counsel or as the trustee and the board, get the benefit of the quasi-judicial immunity that comes with that kind of court approval. And so that is something you really need to think through carefully to protect the quasi-judicial immunity that is enforceable in some circuits like the Ninth Circuit. And that would certainly help in order to maximize the value there for the trust. How about the next slide, please? Now, Eric, why don't you tell us about what happened in the GM bankruptcy and the litigation funding that was done there?
Great. Thank you, Cathy. I think the GM case is a pretty good poster child for a lot of what you were talking about, which is really the value that litigation funding can bring to a litigation trust, and specifically a litigation trust that arises out of a bankruptcy. The reason I say it's a poster child is because we were able to obtain a very successful recovery. We secured $231 million ultimately in settlement for the trust, and that is a recovery that was distributed to unsecured creditors of old GM, of General Motors, and also was distributed to the DIP lenders to General Motors. And it is simply a fact that we would not have been able to litigate the case to conclusion, and we would not have been able to realize that value for the constituents of General Motors were it not for litigation funding. And the reason for that is it is a case where the trust was up against JP Morgan and hundreds of other financial institutions that was represented by a consortium of fantastic large national law firms. And it was very clear that their strategy was to bleed the plaintiff dry, to litigate a war of attrition and cause the plaintiff to run out of funds. And so it was critical for the trust to obtain funding in order to carry on the lawsuit. And as you said, the funding was important not only to give the trust the resources to carry on the lawsuit, but also to level the playing field and to signal to the defendants that the trust had the financial wherewithal to litigate the case to conclusion, because that's ultimately what made it possible to bring the case to a successful conclusion. This trust, it was very simple in that the trust held only one asset, and that was this litigation. It was litigation that was first commenced by the Official Creditors Committee on behalf of the General Motors estate, and then standing was very explicitly transferred to the trust, and the trust took over the lawsuit. At the time, the trust was funded, I would say, with enough money to litigate and lose. There wasn't enough money in the trust to litigate and win the case. Another important feature about, I think, this litigation funding example is that it was funding that had to be approved by the bankruptcy court. We had no issues whatsoever getting the funding approved by the bankruptcy court. So the bankruptcy court reviewed the litigation funding, approved the funding agreement, approved the trust entering into the funding. And I think that, at the time that we did this, litigation funding was increasingly becoming a part of bankruptcy practice. And I think now it's accepted more as a standard feature of practice. And so I think for bankruptcy courts that have seen large commercial litigation, it is not unusual for them to be presented with litigation funding agreements for approval. Let's go to the next slide, please. So let me tell you just a little bit about the substance of the case, which I think can also help you understand where litigation funding fit in. At the end of the day, the case was about, I'd say, a very small mistake, a mistake that any of us are capable of. Certainly I'm capable of making a mistake like this, but it was a small mistake that had enormous consequences. The simplest way to think about it is General Motors and JP Morgan had two loans. One was a synthetic lease loan, let's call it Loan A, and the other was a $1.5 billion term loan, let's call it Loan B. Loan A was paid off. And so JP Morgan and OGM intended to terminate all of the UCC filings that secured Loan A. And they did that. But accidentally, when they were doing that, they also filed a UCC termination statement that on its face terminated the security interest in all of the equipment that also secured Loan B. It was a mistake. It was very clear that there was no intent to terminate the security for Loan B. And so the first issue in the case was really a pure legal question of whether this mistaken UCC termination statement was legally effective. That the trust was initially funded with $1.5 million, and that proved to be enough money to litigate what we call phase one of the case, which is this pure legal issue. We litigated through summary judgment in front of the bankruptcy court. We took a direct appeal to the Second Circuit. The Second Circuit referred the UCC question to the Delaware Supreme Court. I got to argue that case before the Delaware Supreme Court. Then it came back to the Second Circuit, and ultimately we, the trust, prevailed on the legal question, and the court found that this mistaken UCC filing was a legally effective filing, and so it terminated JP Morgan's loan on all of the equipment that secured Loan B. And that's when this case got really complicated, because the Loan B, this term loan, was secured by all of General Motors' equipment and fixtures in pretty much all of its North American plants. And so now we have before us a question of what is automotive equipment and what is a fixture for purposes of the UCC. And as you can imagine, JP Morgan and the syndicate of financial lenders and their counsel argued that pretty much everything is a fixture. And therefore, the UCC termination statement barely terminated anything because everything's a fixture, and what was terminated was just equipment. And what the trust argued, of course, was that just about everything is equipment. This dispute ranged across 100,000 assets in approximately 40 different plants. And so what we did, and this is phase two of the case, we went to trial on 40 representative assets that we chose. Is a robot a fixture? Is a conveyor belt a fixture? Is a crane a fixture or equipment? So we litigated the representative assets in a very hard-fought, intensive, expert-driven trial in front of the bankruptcy court. And as we were getting to the end of that trial, we had approximately $200,000 left. And there was so much more distance to go. We ultimately got a decision in phase two. It was a mixed result. Some of what we argued, some was equipment, some was fixtures. And then we got sent to mediation where we had to try to extrapolate and apply the court's decision across the range of the approximately 100,000 assets that were in dispute. The mediation itself required multiple mediators. It required many, many sessions. It required lots of presentations, lots of expert-driven work. And if the mediation were not successful, we anticipated a phase four of the case, which was then to take some of the remaining disputes and go back to trial in front of the bankruptcy court. So it was a very complicated and very phased litigation. Let's go to the next slide, please. So the trust's funding needs were structured around the different phases of the litigation. As I mentioned, initially the trust was funded with $1.5 million, which took us to that appeal and took us most of the way through the representative assets trial in front of the bankruptcy court. Because our trust also benefited General Motors DIP lenders, which in this instance was basically US Treasury and also the government of Canada, very unusual, but the government was willing to fund the trust with $15 million of interest-free money. So I don't think there's a lesson there that is of any use for the future. But if there's any lesson, I guess it's if someone offers you an interest-free loan, you should take it. But beyond that, we needed money, and actually, we worked with Burford to secure funding for the remaining portion of the case. That's the funding that ultimately was approved by the Bankruptcy Court. And as we neared the end of the mediation and we saw that there was a prospect of having to head back to trial, it was really important for us to communicate to the defendants that we were well funded and that we didn't have to settle because we were running out of money, that we would go back to court if we had to. And we were able to secure yet another round of funding that was approved by the Bankruptcy Court. Ultimately, we didn't need to use much of that funding because we were able to use that funding to really persuade the defendants that we were for real, we were going to go back to trial, and we were able to secure a $231 million settlement for the trust. Let's go to the next slide, please. So just reflecting back on that experience, as has been talked about, it is really important to think about how litigation funding fits into your trust documents. Our trust documents specifically allowed for litigation funding, and in particular, explicitly allowed the trustee to pledge recoveries from this litigation in order to secure litigation funding. So I think that that was important. If our trust documents had not been quite as explicit, I think we still could have gotten litigation funding, but it would have been much more open-ended and it would have been left up to the court in a different kind of way to assess the reasonableness of the funding. So I think being explicit about your trust's ability to get litigation funding is important. Our trust had a trustee and it also had a trust monitor, a kind of overseer. Our trust monitor was a retired bankruptcy judge in the Southern District of New York, the former chief bankruptcy judge, Arthur Gonzalez. And it was very important to him, in particular, that we really secure the absolute best deal possible for the trust. So to get the funding, we actually engaged in a fairly competitive process, and we invited a number of very reputable litigation funders to put in bids. And we, in addition to trying to get the best financial deal for the trust, because ultimately that would mean the best recovery for its beneficiaries, there were also non-financial considerations that entered into it. The reputation of the funder was very important to us. The kind of working relationship that we developed with the funder was also very important. I mean, I think we really came to see Burford as a partner in the litigation. And even though, as Cathy and Emily both said, all decisions about the litigation were entirely left to the trust and to counsel, we actually affirmatively found it helpful to have Burford as a sounding board, to have someone who was outside the litigation, but who was also very invested in the outcome, as someone to test theories and run ideas by. And of course, maintaining the independence of the trust decision makers was very important to the trust and was not an issue, and as everyone has said, in general, is not an issue, because just as a matter of ethics, it's critical that the litigant remain in control of the litigation. Another thing I'll say about the General Motors experience was that I found that the due diligence process itself really helped us in our case analysis. When we were soliciting funding, we had to really think through the end of the case at an earlier stage in the case. And any good trial lawyer, of course, you get a new case in the door, you want to be thinking about what does the closing argument look like. But in such a complicated case, I think the funders demanded a level of granular analysis that ultimately was very productive in terms of our own ability to set strategy and understand the risk-reward ratio in our case. So I think the due diligence process can be a very fruitful process. And as I said, were it not for the litigation funding, there's no question that I would not be here describing this as a success story. In a good case scenario, I think would have been a case that we would have had to unfortunately settle on the cheap and never would have been able to obtain the kind of recovery that we did for General Motors stakeholders. So let's go to the next slide. And let me turn it over for a discussion of the MagCorp case.
Thanks, Eric. And let me, Eric is very kind to say that funding really made the difference on the case, but I don't want to let it go without saying, really how important the work of the lawyers were, and how, they could have easily been overwhelmed by such huge opposition, and really having a good working relationship with Eric and his partners and their firm, and understanding the quality of the litigation that they were going to bring to the case, and the strategic thinking about it, and the ability to manage a case of this size was incredibly important to us, as in thinking about putting $15 million into a case, and ultimately incredibly, the case could not have been won without outstanding lawyering. So, I do want to just commend Eric on the incredible job they did on bringing that case to a successful resolution. Let's see, Mag Corp. So this is another case that actually Burford funded. It's, I guess, plug Burford Day on this panel. But this is a case. This is a great example. Eric's the GM case is a great example of a sort of more traditional litigation finance case where the capital is being provided to actually pay for the litigation fees and expenses and trust expenses as a case is being litigated. Mag Corp is a great example of a monetization that was done in a liquidation context. In Mag Corp, the company Mag Corp was a subsidiary of Renco, an Ira Renner company, and it filed for bankruptcy in 2001, eventually converting to a Chapter 7 liquidation. The Chapter 7 trustee brought an avoidance action against Renco, the parent company, for transferring cash and assets out of the subsidiary and leading to its bankruptcy. And ultimately, after many years of litigation, recovered a jury verdict in the Southern District of New York of $213 million. In 2016, the trust was really almost completely out of money and was looking at bringing a appeal of the judgment, which was really the only big significant asset left to recover on behalf of creditors for the liquidator. So it really was important for that recovery to be protected and to manage the risk around it and make sure that there would be some kind of recovery for the creditors in the event that the case was overturned on appeal and had to go back to trial. So the trustee really, this was pretty innovative at the time, decided to run a 363 sale for a portion of the litigation proceeds generated by the judgment if it was successful on appeal. They ran a process. They identified a stalking horse bidder and entered into a stalking horse agreement with that bidder, and then ran a public auction. And the auction generated $26.2 million for Mag Corp on a non-recourse basis. And it was a competitive auction. There were several bidders, and it drove up the actual price or amount of cash that the trustee was actually able to win in the auction. I think the original stalking horse bidder was at something like 24 million, or maybe closer to 25, and the auction ultimately generated over 26. So it was a non-recourse. So if the case lost on appeal, there would have been no recovery for the winner of the auction, which was Burford. And if the case won, the litigation funder would recover its capital investment plus $50 million plus some interest over time. This transaction, it was a 363 sale of the right to the future proceeds from the litigation, and the bankruptcy court approved the transaction as reasonable in the best interest of the creditors. Obviously, the fact that there was an auction and there was a transparent market process for generating the proceeds and making sure that the auction was at a reasonable market price was an important factor. The court also, I think, really deferred to the judgment of the trustee that it was important to make sure that the trust was able to go forward with litigation, and that they would absolutely preserve some recovery for the creditors in the event that the litigation ultimately was unsuccessful. And it did, in fact, approve the transaction over objections by some of the note holders who thought that the transaction was too expensive, and also approved the trustee's rejection of an alternative offer from Renco. So, and the happy story at the end of the day for everyone was that the judgment was ultimately affirmed. Burford recovered its return, and the trustee was able to secure a significant recovery for the creditors. So that is the MagCorp story. Cathy, over to you to talk about what can go wrong. So you're on mute still. Next slide, please.
Sorry about that. What I wanted to just say about the MagCorp case was make sure we included the case number on all three of these so that you as the attendee could go ahead and look at the dockets, go on and look at the rulings of the case and some of the results. Sometimes the funding agreements are exhibits to these cases. And so it's helpful, I think, for the practitioner to be able to see those types of things. In the MagCorp case, what was also interesting was the transcripts are there so that you can see the judge's discussion about how he thought it was reasonable, even though it was expensive funding, he thought it was very reasonable, and how nobody at the beginning of the case thought it had any value at all. Leo Buse took it on a contingent fee. He litigated for 14 years before they got the judgment. And so the point is with the funder coming in, it guaranteed at the end the trustee was going to get some of the money. And then when it was totally successful, the trustee still got almost $100 million to be able to distribute. It really is a success story and is a really good example. I would encourage you to look at the pleadings in that case and the rulings. Now on this particular slide number 13, I want to talk about what can go wrong, because this was one where prior to the bankruptcy, the plaintiff, the debtor, actually entered into funding with a specific entity to fund litigation. And when it did that, there was a lot of controversy in the subsequent bankruptcy about the conduct of the law firm that represented the Epic Center and the pressure that it brought upon Epic Center to do this. It had it on contingent fee, but it was not going to continue to represent them if they couldn't get funding. And so therefore then they brought the funder in order to talk. This is an example, I think, of where you need to be, as plaintiff's counsel, you need to be aware of the conflicts of interest, and you may need to bring in special counsel in order to assist the client, the actual plaintiff, in looking through and thinking through the issues. They did eventually, Epic Center did agree to the financing. The plaintiff was successful in the litigation. They ended up getting a substantial judgment, but of course the defendant didn't have cash. And so in order to settle it, what they ended up doing was the plaintiff ended up taking real property as the collateral, not the collateral, real property in exchange for the judgment amount. So then how would you pay back the funder? How would you pay your contingent fee law firm? They ended up giving the funder a first deed of trust and gave the law firm a second deed of trust. They gave them they negotiated a specific time period for the property to be sold to pay off those deeds of trust. But of course, the property didn't sell in that time frame. And so the funder started a deed of trust sale. And then the debtor, the plaintiff, decided to go into a bankruptcy. And as a part of the bankruptcy, what it did was brought in a lawsuit immediately for the fraudulent conveyance of the right to recover, equitable subordination because of the conduct of the parties, the recharacterization of debt to equity, and also objected to the claims and objected to the law firm's breach of fiduciary duty and those types of things. So it was really nasty. And while you don't expect these things to go wrong, this is an example of where it really could go wrong. What I was interested in as we get to the rest of this case, and let's go to the next slide, please. What I was interested in just kind of observing the case on the outside was, would the Arizona court, this was an Arizona bankruptcy case, eventually uphold the funding? because the funding, of course, was expensive. It was third-party litigation funding. And the bankruptcy court did uphold it and did find that there was sufficient consideration given risks that were involved, and was able to support the funding itself and to support the remedies that were given and the deeds of trust, and also dismissed the equitable subordination because it found that the lender was not an insider. There had been a subsequent transfer of the claim to another lender that was involved. And so the court then dismissed the subordination and the fraudulent transfer and upheld the claim of the funder. It did not dismiss the adversary against the law firm. And so there was still some question as they went through the case that was eventually settled with regards to the law firm. And and it went up to the Ninth Circuit, a bankruptcy appellate panel, and it was affirmed. But the interesting thing also is that the funder was then in a position with a valid claim to bring a competing plan to the debtor. And in bringing the competing plan with the debtor, it was able to get the support of creditors. And its plan provided for the real property to be placed into a trust so it could be sold. And with the sale, the lender would be paid, the second lien of the law firm would be paid in the settled amount, and then the creditors would get paid as well. And so that was a unfortunate way to have to go through and look at what was wrong. But I think there were lots of lessons there for the law firm, for the funder, and for the debtor to see and understand as it went through the process. So I think that's all we're going to cover for today's program. But Emily, while we're waiting to see if there are going to be any questions, I want to encourage the attendees, go ahead and send in your questions now so that we can answer those questions if you have anything. But in the meantime, while we're waiting for that, Emily, why don't you tell us what would be your major takeaway from today's program?
Thanks, Cathy. And thanks everyone for listening for the last hour. I think the main takeaway from my perspective is to keep litigation finance in mind as a tool as you're approaching liquidity issues, either pre-bankruptcy or in bankruptcy. That litigation, that the company may have can be a financeable asset, and litigation funding is a tool that is much broader and more available than seeking contingency fee firms, which can be fabulous, but might not always be the right fit and the best fee structure for pursuing claims. And I guess I would add that very few firms will take on out-of-pocket expenses on a contingency basis these days. So, anytime you're sort of looking around for a solution, I think it's worthwhile to reach out to a funder and think about litigation finance as a potential option.
Cathy, I'm sorry, I think you're on mute.
One of these days I'll get this down right. But we don't have any questions yet in the chat room. So why don't you go ahead and tell us what your takeaways were?
Sure. I mean, I think this is a variation on what Emily said, but what I'm seeing, at least in bankruptcy court, is that companies try to get to confirmation more quickly, maybe than in the past, and as a result, they end up establishing litigation trusts as part of their plan, where a whole bunch of claims get put into the litigation trust, and then it becomes the job of the trustee to sort through it, figure out what the trust has, what's valuable, what's not valuable. And I think that if you're advising a litigation trust in even a medium-sized corporate bankruptcy case, you should have talking to litigation funders on your checklist of things to do, because sometimes it is the most cost-effective way to get the funding you need to be able to bring litigations that may be valuable. And as I mentioned when I was talking about the GM case, I think the process itself is helpful to you as a trustee to really get an early outside assessment of the value that the claims in your trust may have.
Well, I'm still looking at the chat room and there's not a question there. So let me tell you my takeaway before we end the program and what we're doing. Emily had said it's a tool, and it definitely is a tool in our toolbox, and we need to be aware of it. Even outside of bankruptcy, I think boards of directors should be looking at and considering doing third-party litigation finance for the financing they have, whether it's for IP, whether it's for trade secrets, whether it's for business interruption insurance, which right now is a very hot topic. Those are the types of things that I think a board should be looking at. So in a bankruptcy, the same thing. The debtor, the trustee, our liquidating trust, they should all be looking at whether or not litigation funding will enhance the assets that they do have with this litigation. Is it a way to monetize it and be able to pull the value in so we can pay other expenses first and not have to wait to the very end of the case? I mean, that was the interesting thing in MagCorp, that they were able to pull in the trustee, even after 14 years, 12 years, was able to bring money in and pay out administrative expenses and to be able to pay some of it so that he didn't have to worry about that aspect of the case. So in my mind, there's nothing to lose if you are on the board or you're the trustee or you're the liquidating trustee. Look at the litigation funding, approach the funder, call Emily and say, is this something that you guys would look at, you would entertain? What would be our cost? What is it like? And at least you have nothing to lose. She's not going to charge you for doing that, for just, giving her the opportunity to look at it. You have nothing to lose by finding out if litigation funding is an alternative. You can always say no to it. And as a part of that process, you might be making the best decision for the beneficiaries of a liquidating trust, or for the creditors if you're a Chapter 7 trustee, or if you are debtors counsel in a Chapter 11 and you wanted to be able to make sure all the fiduciary duties are being fulfilled. So in my mind, that is the takeaway from today. We've each had the opportunity to do takeaways. I think we are probably now at the end of our program. We want to thank you again as our audience for letting us go on for an hour and talk about something that we obviously are very interested in and that we see the value of. So be sure and go to the front page and second page, use our email address, contact us, reach out to us, and see if there's anything that we can talk through with you and otherwise help you to make the right decision for your clients. So we thank you again. Good day.
Thanks, everyone.
Thank you, everyone.